Hello friends, hope you are fine and doing well. I give you very warm welcome to our online classes. We have initiated a small program or CRPC on fingertips. I hope this program is going to be very useful for those who have been preparing for the competitive exams, who are in regular practice and who have been pursuing their LLB. So before I come to the lecture, I would love to discuss the basic things about the criminal judicial system and the basic thing as to how the criminal case is initiated and how the investigation is conducted. So the basic thing which we need to understand, there are two ways to initiate the criminal proceedings. One is that whenever an offence or the crime takes place, the remedy before the victim is to approach the concerned police, the area wherein the offence has been committed, and the second is that he can lodge a complaint. So today we would be discussing the most important and significant chapter of CRPC, that is chapter 12, which contains section 154 to 176. There are total 26 sections and few additions, few amendments have also been made, but the basics are 154 to 176, and the amendment in 166A, 166B are also there. But we would be discussing the overview of all the section. I would try to give you the conceptual clarity and the basic understandings so that you become confident, and I personally believe that the people who are into a practice or preparing for the exam, they have to have command on these basics provisions. So let me start with the concept. The moment FIR is registered, the police gets into the action and proceed with the investigation process. Now the investigation is the basic foundation on which the whole case is based. Fine. If the investigation is conducted in a just and fair manner, it provides an aid to the prosecutions as well as to the court to adjudicate the matter fairly. So the basic foundation where the whole structure, from where the whole structure of a criminal case is to be built up is there, and I personally believe that the command and the mastery on this provision would make everybody the confident and a learned one. So here I start the section 154, which deals with the FIR. See, the meaning of FIR has not been defined under section 154. Only the mechanism has been provided as to how the FIR is to be recorded. So the simple meaning of FIR is hidden inside the term. First information report, the information which is given at first point of time by the informer to the police officer in charge of the police station. So by whom the information is to be given? Anybody. The cardinal principle of criminal law is that anybody can set the criminal law into motion. So there is a misnomer that it has to be a complainant, it has to be a victim, or it has to be an aggrieved one. It is not so. Anybody whosoever has a knowledge about the commission of cognizable offence can report the matter to the police. Fine. So what is cognizable? Now 154 deals with the cognizable offence. There has to be a commission of cognizable offence, then only the FIR has to be reported. So cognizable offence, it has been defined under section 2C of CRPC, which simply say that wherein the police can arrest without warrant or initiate investigation without the permission of the magistrate. Now after lodging the FIR, the police gets into action and it is to conduct the investigation for the purpose of nabbing the culprit one, collection of evidence two, and then to secure the presence of the accused after making his arrest before the court of law, and then ultimately to prevent the crime so that the same person should not get indulged to any other criminal activities. So there are so many objects of the investigation, but the main object as it has been provided under section 2H, that is a collection of evidence. So it has to be conducted in just and fair manner. Number of judgments Supreme Court has time and again held that it should be conducted as per the parameter laid down as per the provisions contained and as per the provisions of the CRPC. Fine. So, this very chapter, chapter 12, it actually empowers the police to investigate the matter in a fair way. In fact, I would say that police derives its power to investigate the matter from this chapter only. So, if the question comes as to the chapter which deals with purely with the investigation, that is chapter 12, section 154 to 176. Now, section 154 deals with the registration of FIR. Section 155 deals with the non-cognizable offences. So, two kind of offences. See, there are a lot of classifications are given: bailable, non-bailable, compoundable, non-compoundable. Then comes the cognizable and non-cognizable. Now, the non-cognizable, you could say that it is less serious in nature, or you can say that which amounts to a private wrong. Fine. So, non-cognizable, wherein the police is always required to seek a permission from the magistrate to initiate the investigation, and police cannot arrest without warrant here. But once the permission is granted, please please note that once the permission is granted by the magistrate, police gets the similar power as it had in section 154, but still the police cannot make an arrest of the accused in a case of a non-cognizable offence. Then comes the most important section 156. 156 empowers the police to investigate the matter, and the question on the process which is initiated by the police under this section cannot be called in question at any stage, right. 156(3) further provides that if in case police refuses to register the FIR, or police is not pacing up the investigation, then you can approach the concerned magistrate with the request that they be directed to register the FIR or to swift the investigation process. Fine. 157 lays down the procedure as to how the investigation is to be done. 158, the report is to be submitted to the magistrate. This is just to put a check and balances upon the police action or the proceeding they are conducting. Fine. 159 deals with the inquiry. In case magistrate thinks so, he can order an inquiry, or he can order for the investigation as well to the subordinates if he feels that this is not being conducted as per the parameter laid down under CRPC. Then see, investigation involves a lot of steps. I mean, the police has to ascertain the fact, police is to discover, police is to conduct search, police is to record the statements of the witnesses who are acquainted with the fact and circumstances of the case, and then ultimately arrest the accused, and a lot of other things like in order to establish the guilt of the accused in a court of law. So, a lot of processes are involved in the investigation process. So, 160 is one such section which empowers the police to summon the person acquainted with the facts and circumstances of the case. So, 160, the police issues the summon. Under section 161, the statement of the concerned person is recorded, and then 162 provides that it should not be signed by the maker. There are certain reasons to it which we would be explaining in the detailed lecture in the coming times. Fine. Then section 163 deals with the search during the investigation. Fine. 164 as to how the confession is to be recorded. So, there are two kind of statement, one is a confession, other is a non-confessional. Both statements are recorded under section 164 by the magistrate, but obviously the magistrate has to warn and has to warn to the person concerned, and then the voluntariness of the statement is to be checked because the one is admitting the guilt. So, the provisions are there, like which are required to be followed by the magistrate, so that the person concerned should not be put into any jeopardy or the peril of being punished. Fine. So, section 167 is another section which is very, very important, like which deals with the remand in case the police is not able to file the challan within the stipulated period of 60 days or 90 days, as the case may be. Fine. Then in that case, how the further detention is to be authorized by the magistrate. Fine. And then comes the default bail. The concept of default, 167(2) deals with the concept of default bail, and again this is very, very important. There is a divergent view of a number of high courts on this issue, but there are landmark judgments on 2-3 point of controversies, fine, which would be again highlighting in the detailed lecture. And then comes the 169, again a very important section, the closure 169, which deals with the closure report, and the 172 deals with the police diary. Now what this diary is, when it could be used, and then comes the section 173, this is the final report. Once the police completes the investigation, it is required to file the final report. But what is the concept of investigation, reinvestigation, and the further investigation? What is a supplementary challan? All these things like we will be discussing in the forthcoming lectures. Here we are discussing the overview of these sections today. The warming up section, you can say, is going on, and then comes the 174 and 176, which deals with the inquest report in case the person dies under the unnatural circumstances or death happens under the mysterious circumstances, then how that is to be taken care of. 176 deals with the serious cases of custodial death, as to from by whom the inquest is to be conducted. So it is another safeguard. It is not by the executive, it is by the judicial magistrate. So we will be discussing all these provisions in the coming lecture. For today, I think it is enough for today, like just to give you the broader view, and then we would be touching each and every provision in detail in the light of the judgments passed by the Honorable Supreme Court. Fine. Thank you so much.